Hi there, it's Hillardis again. Today we're going to be looking at the judicial branch, courts, and different types of laws. Big ideas that we're going to be looking at. First of all, we're going to be looking at the three levels of federal courts. That's the district, the appellate, and the Supreme Court. Different levels of the federal courts each deal with different caseloads, ensuring all citizens receive a speedy trial. That is one of your original 10 amendments. Supreme Court's decisions have wide-ranging effects because court justices interpret the meaning of the Constitution. Okay, one of the main things that you need to take out of this PowerPoint is the main job of the judicial branch. The main job of the judicial branch is to interpret the laws to make sure that they are constitutional. So laws in 1950 may have been constitutional then, but over time, the constitutional, at least the interpretation of the Constitution, can change. Supreme Court justices weigh many factors and go through several complex steps before making decisions. We're going to be looking at that. Our laws today can be traced back to early legal systems, mainly the English common law. There are thousands of criminal cases each year. That's why we have different types of court systems, which you guys will be learning about shortly. But first, the federal court system. Our federal court system exists alongside 50 separate state court systems. So each state has a state court system. The state courts get their power from state constitutions and laws. But what you have to remember is that federal law will always trump state law. So take what's going on in Colorado right now. They had just legalized marijuana, but because at the federal level it is not legalized, it is illegal. If you are caught with marijuana by a federal police officer, you will be arrested and be charged with a federal crime. But like I said, there is one federal court system, but there are 50 state court systems, but they are all set up very similarly. The federal court system, first of all, jurisdiction is the authority to hear and decide cases. So it really depends on jurisdiction to where a case will be decided. The Constitution gives the federal courts the power to deal with cases that involve the Constitution, federal laws, disputes between states, citizens from different states suing each other, the federal government, foreign governments and treaties, maritime laws, and U.S. diplomats. If you want to get a couple more examples, you can look in your civics books on page 241. But federal jurisdiction is pretty wide-ranging when you look at this. Under the Articles of Confederation, which you guys learned about earlier in this semester, there was no federal court system in place. All of this was just given to the legislative branch. And as I said earlier, the Articles of Confederation just didn't work. It was a good idea at the start, but because all the power was in one area and the federal system didn't really have any power to begin with, there was no way of doing some of these things. So dealing with foreign governments and treaties, or with U.S. diplomats, or if a state sues another state, there was no way the federal government could step in under the Articles of Confederation like they can do now with the judicial branch. The types of jurisdictions. You have exclusive jurisdiction and you have concurrent jurisdiction. Exclusive jurisdiction only means that the federal courts may hear and decide cases. All right. It means they exclusively have jurisdiction. So if you broke a federal law, they will have exclusive jurisdiction on you. But there aren't too many exclusive jurisdictions because most of the federal laws are also state laws. So you get things like concurrent jurisdiction. Either state or federal courts can try you depending on what you did. All right, U.S. district courts. So the district courts are the low man on the totem pole when it comes to courts. The district courts are really the workhorses of the court systems. In the district courts, these are this is the place where you see judges. This is the place where you see juries. This is the place where you see different types of evidence coming up. This is the place where you can pull up witnesses. All of those things happen in district courts. So I've always said, if you watch Law and Order, those are district courts. All right, there are 94 district courts in the entire United States. There is at least one per state. Now, the bigger states, depending on population, of course, are going to have multiple district courts, because if you just have one district court in California, it's going to get really backed up. But if you put one district court in, let's say, Alaska, it won't be as difficult because there are less people. These are the only federal courts with witnesses and juries, like I said earlier. Okay, in a district court, after your trial is over, whether you're guilty or not guilty, you have the ability to appeal your court decision if you don't like it. If you appeal it, you would appeal your sentence to the Court of Appeals. Okay, it's a higher court than the district courts. The appeals courts review decisions made in lower district courts. There are 12 U.S. appeals courts spread out geographically around the U.S. and one in Washington, D.C. So there are 13 total U.S. courts of appeals. In the U.S. courts of appeals, there is no jury. There is no witnesses being pulled up. You don't see what goes on in the district courts like you see in the appeals courts. There are 3 appeals judges per court. They basically just look at the facts, they look at the laws, and then they judge whether or not that should be appealed. That court case should be appealed. Now, announcing your decision. When an appeals courts make a decision, one judge will write an opinion for the court. This offers a detailed explanation of legal thinking behind the court's decision. The reason why they write these opinions, is because this gives other judges guidance or precedent from that court case. That precedent will then go even further into the future. So let's say you committed some sort of felony. Later down the line, somebody else might be committing that same felony, but the judge or the lawyers will look back on your case that gave that judge precedence and take the ideas from that case and kind of put it towards your case. So they're going to look at how a judge ruled way back then and then decide whether or not they want to rule the same way. A lot of times they will rule with precedence, but if they decide to not go along with the precedent, that means that they are breaking precedent. Okay? That's an important term to know, breaking precedent. Okay, federal judges are appointed by the president and approved by the Senate. Okay, they may keep their jobs for life. All right, as you can see here, this is how a district court is usually set up. So you have your jury, you have your audience, you have a judge, you have a witness, you have the plaintiff, you have the defendant. All right. All of those things. That's basically your regular setup of a court. Hopefully most of you won't have to see the inside of a courtroom, but if you do and you go to a district court, that's usually how it's going to be set up. Attorneys and marshals. U.S. attorneys work for the government and prosecute cases in which federal laws have been broken. Then you have U.S. Marshals. They're like the cops, okay? They make arrests, collect fines, take convicted people to prison, and serve subpoenas. A subpoena is basically a paper telling you that you have to go to court. Now, if you do not like your court case from the appeals court and you decide you want to appeal one more level, you have one more level to go, okay? Your third level. It is the Supreme Court. The Supreme Court hears cases that involve diplomats and arguments between states. Okay, those are a given. Those will go directly to the Supreme Court. They also review cases from the Court of Appeals. They get to pick and choose which court cases that they actually get to see. There are between 7,000 and 9,000 cases per year appealed to the Supreme Court. But unfortunately, because there's not that much time in the year, you can't see 7,000 to 9,000 cases and expect to do a good job. They usually hear less than 100 of these cases. Usually when they take a case, it has to be a big deal. Like Brown versus the Board of Education, when segregation was deemed illegal, or Roe versus Wade, when the right to privacy was passed through. It usually has to deal with laws that are going to be overturned or laws that are going to be knocked down and put in place. Opinions. Like I said earlier, judges have to write opinions after they've created a decision. You have a majority opinion. So the winning judge, so there are 9 judges in the Supreme Court. After the opinion or the ruling comes out, the majority party, so whatever the number is, the majority party, let's say 5-4, one of the judges in the 5 majority party will write an opinion. A concurring opinion. It's written by a justice that agrees with the decision, so they're in the majority party, but they believe, that the court case went that way for a different reason. And then you have dissenting opinions. So a dissenting opinion is written by a justice that disagrees with the majority opinion, so they're in the minority. There are different types of court cases that you see. You have criminal laws, so you commit a crime that you seek to prevent people from deliberately or recklessly harming one another or one another's property. You have 2 different people in a district court usually. You have a plaintiff. They're usually the ones complaining or suing someone. And then you have the defendant. They're the ones that are being accused of the crime. So they're the ones that have to defend themselves. That's a good way of remembering it. Complaintiffs are complaining. Defendants are defending themselves. Okay, different types of crimes that people commit. You have felonies. Felonies include murder, rape, arson, robbery, and other serious crimes. There are also misdemeanors. Vandalism, stealing inexpensive items, punishable with a fine or jail time. Now, the difference between jail and prison. If you are in jail for less than 1 year, you stay in jail. But if it's over 1 year, you go to prison. All right, obviously, a felony is worse than a misdemeanor. Because with felonies, I mean with murder, rape, arson, robbery, chances are you're going to prison. There's also civil law. So you have criminal law and now you have civil law. Civil law is concerned with disputes between people or groups in which no criminal law has been broken. It's basically people just suing each other. So, this guy's dog comes over to my lawn and is digging holes in my lawn. I'm going to sue him because he ruined my lawn. All right. So when a civil case goes to court, it's called a lawsuit. So this person is suing another person for collateral damage, for destroying their lawn. So if you ever watch Judge Judy, that's what you're seeing. You're seeing a civil law case. Tort law. Civil law also covers tort law. So in tort law, a person may suffer an injury and claim that it's another person's responsibility because of their negligence. Doctors have a hard time with this. So when a doctor is prescribing a patient some form of drug to help them, and if it hurts that patient, chances are that patient is going to come back and sue that doctor for hurting them. Or let's say your room is really dirty and your sibling walks into your room and falls down, hurts himself because your room's so dirty. They could possibly sue you because of your negligence for not cleaning up your room. There are also really important decisions that came out of laws. So the Miranda warning. If you're ever arrested, okay, you have the Miranda warning. So you have the right to remain silent. Any statement made can be used against you in the court of law. This has to be read to you word for word when you're arrested, and you have to make sure that you are understanding it. If you do not understand it, you have to say so. All right? A lot of people have gotten off of their crime because cops didn't read this or didn't read it correctly or they didn't understand their rights. A plea bargain. A plea bargain is basically a lawyer giving you a break. All right, he or she will give you a break, and you can plea down, so you can plead guilty to a less serious crime.